Hi, everybody. This is Matt with Provider Trust, and we are very happy to have you here today. I want to first say thanks so much for registering and attending. We've got some great info for you all and are very happy you're here. A couple of things before we get started. One, I want to make sure you guys can hear me okay. So if you'll just say a little something in the questions tab on your control panel there, just so I know you can hear me fine. And also, this afternoon after the webinar, you will receive a copy of the slides, a recording, as well as your CEU certificate. So we are happy and proud to say that this webinar is our fourth that is pre-approved for 1.2 CEUs by the CCB, and we're glad to be able to share that with you all. I know it's something that you guys have to get done, and we're happy to share that with you guys. So moving on, so today we have Mike Rosen, who you recognize if this is not your first webinar, and I know that we do have a lot of folks that this is their first webinar today. So this is Michael Rosen here. He is our co-founder, and he is our thought leader at Provider Trust, along with Donna Thiel, who you will meet in a webinar in the future here. But Mike Rosen he's our fearless leader. He has a lot of great industry knowledge and experience and is able to share things from a very valuable perspective with you guys. So we're happy to have him here, and I'll let him talk a little bit about his friend Alan Lasky from Universal Background.
Thanks, Matt. Thank you, everyone, for being here. We are recording today's session, and we will send it out this afternoon to each of you with a copy of not only the audio but the PowerPoint. So feel free to take some notes, but you'll be getting all of this soon sent to you. I have actually had the pleasure of knowing Alan. Both of us worked together at Kroll previous to this. Our firms merged in around 2006 in the background screening world, and I had the pleasure of working with Alan. He was my head of sales for a number of years after that merger. Alan has as you may know, about almost 20 years experience in the background screening industry in particular. He has what I think is a really great approach to this thought leadership because of the various backgrounds that he has. He actually is a clinician, having had worked at a California healthcare system after he received his doctoral degree in clinical psychology out in California. So he has been a provider, and he understands the pressures that you are in as such. Alan has taken that focus and really built around the compliance aspects in healthcare background screening in particular. He currently is Senior Vice President for Universal Background Screening out of Phoenix, Arizona, headquartered, and he runs the sales there, but really gets involved in the larger enterprise accounts, dealing with helping them build screening and compliance programs, and in particular building out very robust compliance programs. He actually has had, we were talking before the session started, had worked with the Pentagon on helping them on a security program for their military-based civilian screening. So he brings a really great perspective, and we're going to spend this today on two parts. The first will be on the pre-employment screening side of things, and then the second will be on monitoring. So Matt, why don't you take us a little bit through our agenda?
Yeah, thanks, Mike. So as you may know, we at Provider Trust, we call Nashville, Tennessee home. We like to think of it as the healthcare capital of the world. We are currently the fastest growing technology software company in the state, and we love it here. A little bit about Universal. Alan calls California home, but they have offices in Arizona, Nebraska, and Florida as well. So just a little bit about what we do. We like to make compliance and HR processes easier by automating some of those tedious tasks that you all have to do on a daily basis and are responsible for. So we'll talk a little bit more about that towards the end, but that's a little bit about us. Quick overview, just to kind of echo what Mike said. The first two here are going to be presented by Alan, understanding background screening. Then we're going to go into compliance documentation, and then we'll close with some words from Mike Rosen about the differences between pre-employment screening and ongoing monitoring, as well as some of the surprising data behind a lot of that. So moving on here, I will pass it to Mike.
Actually,
sorry,
Alan is fine. Yep.
Sure. Thank you very much, Matt and Michael. And thank you all for joining us today. And I definitely want to provide some applied information to make sure to reduce risk, since there's so much litigation going on in consumer reporting right now. And we hope that you find this extremely helpful, and definitely want to hear questions at the end of what we can assist with further information. To start out with, when we talk about background screening, we are a consumer reporting agency, and we're under a federal law, which is called the Fair Credit Reporting Act. And this law was passed in 1970, and it's designed to ensure that accurate information is reported and to also protect the consumer, which has been updated a few times over the years. And we'll get more into that now about these different laws. When we talk first about what we do report, there's no such thing as just a background check, as you all know. There's different layers of a background check, since unfortunately the way that the criminal justice system works in the United States is decentralized. So we have to collect as much information as possible, and there's a federal level and a state level. With the federal level, as you see on this slide, that we can go back as far back as possible on conviction-based information. However, when it's negative information, when it's non-conviction, we can only go back 7 years. That's federal law that has established that precedent of how far back we can go. There are some exceptions to that in healthcare and a couple other industries, but it's very few and far between. There is that 7 year of non-conviction information, and as far back as possible federally for conviction-based information. But then we have to look at the state information as well. Now, to just take a moment, we'd like to ask a polling question. If you can answer this question, are there limitations on how far back certain records can be reported by a background screening company? You'd all just want to take a second, if you want, to take this poll.
Yeah, while you guys are addressing it, we see that a lot of you are participating. Your options are yes, there are laws, limitations, no, there's not, or you're not sure. And that's okay if you're not sure. We want to make sure that you leave this session very sure of what the law is or isn't, without giving away the answer. All right, Alan. Matt, tell us what we got as far as results.
Sure. So, Alan, can you speak to these answers a little bit?
Absolutely. So there are limitations on how far back we can go with certain records. It all depends on what state the organization resides, also what state the candidate resides in, as well as the different laws specifically. It's even coming down now to municipal laws, which is a concern of ours as a trend, which we'll talk about in just a little bit. From this slide that you see, these are the specific states that have state-specific laws, meaning that if your organization resides in Oklahoma, but you have a candidate coming in from California, we have to apply the most conservative approach to protect your organization, as every background screening company should do. You always want to check this out to make sure they're doing this. Because if it ever goes to litigation, you want to make sure that it's in the state of where your organization resides, since that's where corporate is, or where the organization resides, as well as where the facility is, if it's in a different state or in a different area, as well as where the candidate is. We take all those into consideration at Universal because we want to use the most conservative approach. So if someone's in California, a candidate, yet they're going to work at a healthcare facility in Oklahoma, we have to adopt that 7-year rule and conviction-only information that we can report. That's California law. In Kansas, as you see, it's a little different. Where you see in the last column where it says salary exemption, those specific salaries you see, if someone makes under those amounts, we can only go back 7 years. If they make more than those amounts, we can go back past 7 years. So now we have to understand salaries. As a default, your background screening firm should use as a default, if you haven't provided that information, 7 years in those states that have salary exemptions of over or under that. So if you have a part-time person that's making $15,000 in Kansas, we can only go back 7 years. So we have to apply all these rules. Your background screening firm should always make sure behind the scenes to adopt that of what they report out to you to protect you. In addition, you want to make sure as a best practice that your organization, which Universal and Provider Trust does do both, is using fuzzy Boolean logic. And what this is, the police use this process as we do, where we want to catch as many name variations as possible. So instead of just using an exact name match, which a lot of background screening companies do, we use we look at the variations of the first name, which is not considered an alias name, by the way. It's considered a variation of the first name. And since all court records are kept by first and last name as primary identifiers, not the social security number, unfortunately, we want to have the exact name to provide the court. So what we end up doing is giving the first few letters of the person's first name. So we can catch a Mike and Michael, or a Tim and Timothy, or a Kate and Catherine, based on this algorithm of giving just the first few letters and then the full last name. This will reduce risk more. You want to make sure your background screening company is applying this automatically so you don't miss anything. I have in the past seen things missed based on the fact from, again, an organization a long time ago where they weren't doing that. So you want to make sure that your organization is doing that. In addition, besides the fuzzy Boolean logic, there are alias names. The Social Security trace will find that information as well as what's provided by the candidate, which again, your candidates aren't going to always, if they have a case on an alias name, are going to provide that information. It's very easy to change your name, and although there are cultural and accidental reasons that you may see a name change, people do hide their true identity if they know that they have a case. So it's always best practice to do alias names within your bundled package of whatever you're running in it, so we can catch those name variations on the fuzzy logic as well as the alias names to reduce your risk of missing something. In addition, when we talk about verifications, it's important to know that this is the #1 place on any background check that a candidate is going to lie. We find that more than 46% of resumes contain falsifications, and 70% of college students surveyed would lie, as ASHHRA research shows us. And there are over 50,000 PhDs purchased each year. It's a concern of ours, of course, so we always strongly recommend you do primary source verifications. Extremely important. In addition, we are seeing a trend now, which many of you may have already heard about asking about salary verifications. In certain states, as you see on this slide, Massachusetts, California, and Oregon, just this year there were laws passed, as well as last year with Philadelphia, New York City, and Delaware, of you cannot ask anymore about salary verifications up front. You also want to be careful if you're collecting for employment verifications that you can't get an employment verification. If you're asking for a W form or a pay stub, you want to make sure that someone outside of who's hiring sees that information to be the most safe. We do believe that the trend is we'll eventually see a federal law restricting to ask about salary up front until that person's hired. And talking overall about litigation we see in our industry, as you see from this graph, it is substantially increasing. And there's many reasons why it is increasing so dramatically in our industry. It's some of the articles that have been written talk about the fact that, years ago, private lawyers were focused on the tobacco industry as a strong source of winning class action lawsuits. It is now focused on consumer reporting agencies because there are so many laws, and because of the internet and educating applicants, especially if applicants have cases, they're looking and understand the law to see if anything is not done properly to then bring up litigation. So again, it is always important with what we're going to go over in the next few slides to follow, which will reduce risk dramatically. First and foremost, the EEOC back in 2012 came out with what they called guidance factors. And between the EEOC and the Federal Trade Commission, who is the auditing party of consumer reporting agencies, they have made a strong stance ever since 2012 that these different items need to be followed very closely on each and every candidate that you screen. First, you should always look at the nature and gravity of the offense of each candidate. Is what happened job related? What's the severity of the offense? How long ago did it occur? And is the person a repeat offender? You want to make sure also in any ads, you don't put any blanket no hire policy, like if you have a felony, we're not hiring you. You don't want to put that in writing. You can have your internal policy, but you definitely don't want to just carte blanche not hire someone just because of the fact that there's something on their record without talking to them first of what occurred. And you can reduce risk dramatically by first, of course, speaking with your legal and having a program in place. Look at each individual case-by-case basis and make sure you train and standardize the process for all your requesters. As for a polling question to ask, oh, go ahead.
Oh, I was just gonna say what you were gonna say, Alan. Just to bring up another poll for you guys. I think we have about 6 today, so we have 5, excuse me. But we will run this one. Interested in what you all think. Is a separate release and authorization required to conduct a pre-hire background check? I wasn't sure. So we will we'll give you all about 10 seconds to get everyone to vote here, and then we'll share the results.
And Alan, I know that you and I have talked about this quite a bit. This is probably one of the most litigious areas in particular that is in the marketplace, and you can address that when we close out this poll now.
Absolutely.
It's all yours.
So, absolutely, and you know, a lot of organizations aren't sure in this area, and it's really important. This is, as Mike said, this is one of the areas that is the most litigated against, and I see in the news constantly that this comes up. And to go further on the next few slides, we'll cover what this is all about exactly, since unfortunately this is where a lot of the litigation lies.
Okay. Thanks, Alan.
So when we talk about disclosure and authorizations forms, you do have to have a separate form, and that's going to be in the next few slides. So we'll definitely get back to that. So first, just mention with your screening program, it's always important to standardize your process with the same type of positions that you're hiring for, and not to pick and choose a la carte items on different people. That standardization reduces the risk of any perceived discrimination or and potential litigation that could happen. So you always want to keep it consistent with the packages you create. You can have different packages for different types of job positions, which makes sense, but you need to make sure that it's standardized all throughout your organization. Now, talking about documentation, which will answer that question, that polling question. With forms, this is the #1 area that's litigated in class actions that are astronomical, in the $300,000 to a few $1 million that we see normally in the class actions. You want to make sure that your disclosure and authorization form is #1, always signed by the candidate before any background check is conducted. That you have federal and state compliant language that your background screening company should provide. Like, we always provide our clients with our sample language that is federal and state compliant, and that there is no extraneous language at all on that disclosure and authorization form, meaning that you don't add any additional language. Leave it as is, because the moment that you add additional language, the federal law feels that you are confusing that candidate or that group of candidates, and they may not know what they're signing. So you want to keep it pure, and you want to have them, again, you want these documents solely of the disclosure and authorization form, meaning that they're separate documents. You can't bleed it into an application. You don't want to staple it to an application. You want to have them as separate documents that you provide them. Even if you're doing it electronically, you want to make sure that they're on separate pages on the web than merged into other information, or it will end up in litigation. So solution is using a compliant and separate disclosure and authorization form, keep it purely of the language that's supposed to be on there, and make sure to have it always signed prior to conducting the background check. Extremely important. In addition, talking about other forms that are absolutely needed that are in litigation constantly if they're not provided, the summary of rights document is a separate document. You can find it online, and your background screening firm can provide it to you. There's two reasons why you always have to give it to a candidate, is if you're doing verifications on them, or if you're going to be doing adverse action, which we're going to talk about in a moment, due to the fact that you may not hire them. They then have to have a copy of their summary of rights document. It's just as easy to give that document up front to them. It's just a 2-page document talking about if they have identity theft, of where they can call credit agencies and their rights. It's extremely important that they receive that document, especially with the 2 reasons why. Again, if you're doing verifications or adverse action is being conducted, which we'll talk about in a moment.
Great, we've got another polling question for you all. We'll give about 10 seconds to submit your answers, but if the background check contains adverse information, can you make a decision without notifying the applicant?
All right, we'll give 3 more seconds. 2, 1, too late if you didn't vote. All right, let's see what we got.
And this one's a little more close, and it's understandable because, again, it does get confusing and a little gray area. Anytime negative information is on a report that may influence your decision, it's extremely important to follow the adverse action procedures. Even if you feel that you have a better candidate, having and being conservative of taking this approach, you'd want to talk to your legal if there is negative information to still provide the adverse process, which we'll talk about now. Adverse action was started in federal law because of the fact it wants to provide an opportunity for the consumer to dispute any information that may not be theirs. Because the court systems are decentralized, and because of the fact there could be false positive information just because of the way our U.S. court systems are set up, it's important to give the candidate a right to dispute that information. And that's why it's there and it's required. There are easy steps to follow. And again, this is probably the second most litigated area. And just by following these steps, you're going to reduce your risk dramatically. It always does need to be followed by every organization in the U.S. if, again, there's negative information on a report. So the first step is to provide the candidate a pre-adverse action letter. Your background screening firm should have that letter for you in its state and federal compliant language. You'd want to also provide a copy of their report and the summary of rights document that we talked about. So those 3 different forms would be sent to the candidate. Now, number 4, as you see, the government uses the word reasonable. I wish they would use more of a definitive word, but they always use the word reasonable or other gray area words. It has been tried and tested in courts, and we have found that anywhere between 5 and 10 business days to wait for them to decide if they're going to dispute that information, the candidate, you'd want to wait before you send the final letter, which is on the next slide. And what the final letter would be is the same type of process, which we'll get to in a second. So it's the same 4 steps, but now it's a final adverse action notice with a little bit different of language, saying now they're not going to get hired because they didn't dispute it. Again, a copy of their report and the summary of rights document, and then you can rescind the offer officially and legally. It has been tried and tested in court, and it holds up if you follow these specific steps. And again, you'll have a copy of this, and we're always around after to answer any questions about this process.
Alan, let me ask you a quick question. So what you're saying is it cannot be the decision to not hire somebody based on the adverse information found in the report cannot be made at the same time that you receive the report. You have to give some form of notice to the applicant so that they can say, that's not me, or I thought that was expunged, let me go get that corrected, or whatever the case may be. So Right, so that's what you're saying, is it can't be done contemporaneous with receiving the information.
That's correct. That's
right now,
absolutely correct.
Receive it? Do you have to wait for them to, do you have to know that they received the letter, or is it just mailing them the letter and waiting the 5 days? Okay.
It's mailing a letter and then waiting those business days. It doesn't have to be tracked, but it has to be mailed to an address they have provided you, so you can prove it in court if it ever went to court that this was the address they gave us and we mailed it out and we waited those business days. Some ask if you can send it electronically. That it's still up for review. You'd always want to talk to your legal about that. The most conservative approach is still sending by mail, because that's the way that I think it was originally written, back when it was written, that it'd be mailed out. Also, if there is a dispute, it's important to know that unfortunately you have to wait 30 days of leaving that requisition open. Now that is a long time, and we get the fact that on a Friday, orientation may be on Monday. You can't wait that long to leave that requisition open. Your background screening firm should really finish them within 5 business days or less if there is a dispute, and they would proactively reach out to you based on the fact that the pre-adverse letter gives the information of the background screening company to call if you want to dispute information. Your healthcare organization can also call and file the dispute as well, because every screening firm should have a dispute hotline like we do, where that process is started and there's a proactive communication to your organization saying that there is a dispute and we're going to take care of it as quickly as possible.
Alan,
during that time,
here, Tanya asks a really good question. She says, if a candidate volunteers or self-discloses negative information about themselves during the interview, is the employer allowed to make an adverse decision at that point? What about at the time they sign and return the authorization before the background check is run?
That's a very good question. Again, that's outside of consumer reporting with us. So you're not using a consumer reporting agency at that point. You would want to talk with your legal about the next step, but they're giving you that information directly. So if it is going back to the EEOC guidelines, if it still falls into the fact that you wouldn't hire that individual based on the risk factor, you wouldn't want to speak with your legal and then take next steps. But that'd be outside of consumer reporting, because we didn't even see that information, and nor was there a report. What we do find from time to time, just to let you know, sometimes people would provide information, but it wasn't even reportable. It may be something that they thought it was more egregious, but yet when we look at it, it was arrest that was dropped. They may be so concerned about. So it's it is still good to probably go through the process to see. However, your legal may say it's absolutely fine at the point of what information we have that we can document, and then take next steps without going through the adverse process.
Great, thanks, Alan.
Thank you. And we just have a few more slides here. One of the biggest questions that we get is the ban the box laws and regulations that are coming out. This is another area that is really creeping up quickly. We do feel that there will eventually be, as a trend, a federal law on this. There is a government law that Obama started about government employees specifically following this. And this is where the question on an application says, have you ever been convicted of a felony or misdemeanor? Now, years ago, you could ask that question very easily and get the answer and then make some decision at that point. The issue is there's now 150 municipalities, separate municipalities, and 32 states and DC that have their own specific laws. It is a huge concern of ours because you have to know your state and municipal laws to know how it affects you and when you can ask that question if you're asking it. You can't just have it on an application up front anymore. You have to make sure that you're asking it at the right time if you're going to ask that question. Most of the laws that we see as a trend through the 150 municipalities state that after you've made a conditional job offer or at the last interview before hiring, you can then proceed with asking that question. There's a great document that's online from the National Employment Law Project, NELP, state ban the box laws, that updates it every month. It was just updated this last month that has every law for every municipality. It's a great resource to go to. Again, if you didn't write that down, we can provide it to you later. But that will help you where you're organization resides, where your healthcare facility is outside of your corporate resides, so we can make sure that, you're in compliance for wherever the candidate is, wherever they're going to work from the local system, and where, again, HQ is. So it's really important to know these laws, because there are also teeth in these laws. It's not about just ban the box of have you ever been convicted of a felony or misdemeanor. They've added more statutes onto these laws based on the EEOC guidance factors we went over. Of some of them are even as specific as how long you have to wait for adverse action. Some say you have to wait 10 business days in these certain municipalities, which again is really not fair to employers, I feel, because of the fact that there are laws buried in laws. But again, you just want to know this information. And again, there's a very easy resource online that you can look it all up, and it's updated monthly.
Okay, Alan, thank you very much for that. In the interest of time, I'll spend about 12 to 14 minutes on the difference, though, when you want to monitor after hire somebody, and then we're going to open up for some questions. So feel free to send your questions in for us to address in a minute. Let's ask a quick poll question. Are you guys monitoring your employees and vendors each month? I would like to just get an idea who's on the call, what your colleagues are doing. So yes, you are. No, you're not sure. And we'll go ahead and close that out, Matt. And as we see typically the case, about 80% of you are monitoring monthly, both employees and vendors, which is great, and that's what you should be doing. The 14% of you who are not, or in combination doing one or two of those things, or not doing it monthly, we're going to show you why that's exposing you to some risk. And for the 7% of you who aren't sure, now you know that you should be doing this on a monthly basis. Let's talk about, there's some distinct differences between pre-employment versus monitoring. Alan did a very good job summarizing in a short period of time some very complex and intertwined laws that you should be familiar with, including words, font sizes that have to go on papers. That all has to do with pre-hire. It's a whole nother world when it comes to ongoing monitoring. You can let out the stress in your shoulders. You can take a deep breath, because it's a lot simpler. So this slide is showing you that for monitoring, now this is after you have made the background, you've done the background check, you've hired the individual, day one of employment through the life cycle of that particular employee or vendor. There's a couple of reasons why you do not need a separate release. You do not need a different release or authorization in order to pick up monitoring. So if you use, which a lot of our clients do, Universal for your background screening and Provider Trust for your monitoring, you do not need separate or an additional release for us. You do need the work for Alan's pre-employment. And the reason for that is that there's an exception in the Fair Credit Reporting Act, and it's section 1681, which says that if you are doing this to comply with some type of federal law, which you are, in order to comply with both the OIG special advisory on conducting monthly exclusion monitoring, and the Affordable Care Act actually has some nails in it to help you. As a result, there's an exemption under the Fair Credit Reporting Act, and you do not need to obtain a release to do what we're going to talk about. And that is because ongoing monitoring is not considered technically a consumer report. All of this basically shows you the different laws that say this, but in essence, it is because you are conducting screening to make sure that on an ongoing basis, you are lawfully billing the government with providers who are not excluded and or who hold a license or certificate that's required in order not to submit a false claim. As a result, you do not need to have a separate release, and you need to do on a monthly basis, at least exclusion monitoring. And the reason is liability starts. It doesn't end on day one of employment. When Alan or Universal or your provider for background checks has done the background check, that's great. And one of the things you should include in that package at a minimum, in addition to criminal records, is whether or not they're excluded, because you need to know that before you hire them. Now, that information and parts of the background check become stale the next day. Once you've graduated from the University of UCLA, you always have a degree from the University of UCLA. You don't need to check that. But you could become excluded any point after that date of hire. And typically, and we'll show you the timeline of how those happen, it does follow the person from a matter that is under investigation and or they're aware they're about to become excluded, and that's why they're moving jobs. So when an employee walks in the door or a vendor is being contracted, your risk starts, it doesn't end. And therefore, OIG has made it very clear, and CMS has highlighted and agreed in their guidelines that employers billing Medicare, Medicaid, any CMS or federal healthcare dollars, includes CHIPS, TRICARE, et cetera, you cannot submit a claim on an individual or a entity that is excluded, and therefore you must do ongoing monitoring of your employees on a monthly basis to avoid that risk. So let's provide for you hypertext links that you'll get in the PowerPoint that'll take you to these. There is a link to the guidelines. CMS has made it very clear. The OIG Special Advisory is probably the most instructive. If you have not read it or have not reread it in a while, please take the time to do so. The OIG had not issued guidelines on monitoring or exclusion monitoring since 1999, but they did in 2013, and it's very instructive. It's going to answer most, if not all, the questions you have. Why, on who, how often, where do I go? It's all in there. Separately and more recently, the OIG released, in conjunction with last year's FCRA conference, the two organizations worked together collaboratively to issue measuring compliance effectiveness in a resource guide. Actually, one of our employees, Donna Thiel, who is a icon in the long-term care post-acute side of the world, and we're so happy to have her here. She actually was a client before she came here. Was one of 30 people that were invited to a special event to spend a day or two with the OIG and come up with what are some suggested guidelines. She will tell you that these are not required. They are instructive, and there are numbers and pages of them, so not all apply, but a great resource for you to see how the OIG is going to be holding you responsible and looking at the effectiveness of your program. The reason we mention that is not to brag on Donna, although we love to do so, but is because you will be measured on the effectiveness of your compliance program. And one of the core elements, the 7 elements of an effective plan, is monitoring. So they're telling you how they're going to judge whether you're doing this right, worth taking the time to look at your policies and procedures. Now, the reason that you need to monitor, according to Logic and the OIG, is the employee moves and the records change, and after the background check, things like an exclusion can occur at a federal or state level, and your applicants, or at that point your employee, is not probably going to share with you that they've become excluded. They probably said, I got past the background check, I'm not going to tell them, they don't know, no harm, no foul. That's not the case, because you will be fined by the OIG for having them and submitting bills and or contracting with those entities. Because healthcare employees are very mobile, this is a problem. And it doesn't surprise you probably to know that, especially when you look at RNs who can be multi-state licensed, and they can hop between states using one state's license to work in another if they're part of the Nurse Compact Act, and their problems from other states therefore are even magnified as a worry and risk for you. So a background check has a lifespan, and it is good through the date it is issued and sent to you. However, your risk does not end, and you need to monitor. So let's jump into a poll question. Are all of the exclusions that we're talking about you needing to monitor monthly contained in the OIG's federal list? Everybody's probably, hopefully, heard of the OIG's list, but does it contain all of the exclusions that are out there? Yes, no, or you're not sure? And wow, we got an active group today. Let's go ahead and close out that poll, jumping right in. I'm glad to see this answer. This means a very educated group. The answer is no, it does not contain all of the lists, and almost 2/3 of you are aware of that. Let's talk a little bit about why that's the case by using an example. So you're asking yourself, what is an exclusion and how does it work, and what's the process? Typically, what you're going to find is that an individual, whether they are licensed or not, because either can be excluded, has a problem, a criminal matter they have a matter involving substance abuse, patient abuse, or fraud and abuse, it goes through either the court system or ultimately to a state licensing board if you are licensed. And as a result, that licensing board revokes your license. That's typically where this process starts for a licensed individual. And you need to know that close to 45% of all exclusions in the federal OIG list started with and are the result of a license revocation, suspension, or some type of license problem. So imagine that Matt is brought before the state licensing board as a physical therapist for some type of substance abuse, and the state board then suspends or revokes his license. They may limit it. If it is for a felony involving substance abuse, patient abuse, or fraud and abuse, that's a mandatory exclusion, and the state has to report up to the OIG what action they've taken. They have 30 days to do so, and the states are absolutely horrible at complying with that law. But that is what they've agreed to in order to get Medicaid fraud control funding. So at the state level, either Medicaid fraud is investigating or a license issue turns into a revocation. That then by law says 30 days later that should get to the OIG. The OIG has a simple job. They look and see if that action was a felony for those three things. If it is, they have no choice but to add you to their list, but they have to know about it. Now, if the OIG is the source taking action against you, that's where the problem was being investigated, then you're clearly going to be on their list. There are discretionary exclusions, and those are basically for misdemeanor convictions involving substance abuse, patient abuse, fraud and abuse, or two other important items. One, a license revocation. It is discretionary if it's for a misdemeanor, and default on a federal student loan. We are seeing a lot, almost 2,000 records in the OIG's list that are resulted from a default on a federal student loan. That can get you excluded, okay? So these are various ways in which a individual and or an entity can make their way from state and or start at the federal and get to the OIG. However, the OIG has to know about it if it's coming from the state in order to add it to their list, and that's what's not happening very well. So let's talk in a minute about what is the best way to cover your risk. Before we get there, I think you should be reminded of the fines and penalties that the OIG has the clear authority, issues on a monthly basis, and is not afraid to do so. If you submit a claim, and I want to stress submit a claim, you do not need to actually be reimbursed in order for the fine to occur. The mere submission of a claim to CMS and or as a result, basically CMS, or to a state funding source, the OIG can fine you up to $10,000 for each item on that bill that's claimed, or what we see more often, if it's a non-licensed provider and or not somebody that you're billing for directly, it will be their salary and benefits for the time in which they were employed by you and excluded, and they will multiply either of those numbers by 3. So it's either 10,000 for every item you claim, if it's something that they can see on a billing, or if it's salary and benefits, they'll take that number and multiply it by 3. That's called treble damages. That's because they don't want you doing this. If you self-disclose, if you're monitoring and you find you have an exclusion and you self-disclose, that treble damages will be cut down to 1.5, but it's still a penalty. You also risk the other things that are listed here. Your company itself can be excluded. You can lose rights to bill CMS. It can be considered a false claim for having submitted it. There are other issues that you would be presented with. So we want to give you this next slide, which is a summary that you are liable for submitting claims of an excluded person. The OIG has made it clear you should search on a monthly basis, and at least you should be searching the federal list. However, you will not find all of the exclusions that are there because they also exist at the state level. So let's now talk briefly about data sources and how that is relevant. to the OIG. There is the OIG list of excluded individuals and entities, and if anyone was doubting that a vendor or third party is covered, look at the last E in LEIE, that's entity. That's in the name of the data source. It's very clear that third parties and companies can be excluded. There is also formerly the EPLS list that the Government Services Administration had. It's now housed at sam.gov. You should be searching that in addition. But did you know there are 42 other states? There will one day be 50 states that have them. They should all have published them. Since we've started our business in 2010, there were 15. Now there are 42. So as the new ones are added, they are put into our data set and you get those searched against. But you need to be aware that there are 42 state Medicaid fraud control units that could also exclude an individual. Now, we covered that the OIG database does not contain everything, but another peril of the list is that you can only search it by name, last name, first name, or name of entity. That's a problem when there is a common name like John Smith or Maria Garcia or ABC Pharmaceutical. There will be lots of possible records that come up, and in the OIG site, when there are possible records, the only way to verify it as yours as a matched or non-matched person is with the tax ID number, either the social for an individual or the employer identification number. Without that, you will not be able to make and match the confirmation. So you're going to need that from your file. As we round out this session, I wanted to kind of show you some of the important statistics that we thought you might find interesting. Today, as of the last update from the OIG, there are just shy of 70,000 total OIG excluded individuals or entities. There are an additional 69,000 in the SAM database that are healthcare related. There are way more than that in SAM, but if you just look for those from healthcare related entity or healthcare related agencies, it's almost another 69,000, and the states add another 67,000, almost 500 excluded individuals. You need to know that that gives you a total population risk pool of over 204,000 names, and because 43% of all exclusions at the OIG come from a license revocation, that comes from a state issue, and they're not reporting things as they should in 30 days. They're actually reporting on average in over 173 days to the OIG, which gives you great risk in those time frame, at least at the state. Now, you are not liable at the OIG until it's published at the OIG, but you have a problem with the state while you're waiting for the OIG to get it. Last up to date, if you take the number of exclusions and the dollar penalties associated divided by the number of providers that have been issued in these exclusions, the average is over $125,000 for hiring an excluded individual. The stats that we provide here are for you to bolster why you're doing this. We're going to skip the next poll question in the interest of time. We wanted to share with you why licenses and disciplinary actions are important. As we mentioned, almost half of the exclusions in the OIG stem from a license revocation. Here are the top 10 specialties that have a license issue resulting in exclusion. No surprise, nurses make up a good 22,000 of that number, and that's because there are over 2 million nurses. So there's more of them than most other practitioners, but you can see where it then drops off as other practitioners down the road, all the way down to chiropractors, et cetera. And the total number of exclusions with a license revocation is almost 30,000. So I'm not going to spend time on this slide, but for later purposes, this does show you how a person is mobile and hops around and that can try to get ahead of an exclusion. So very simply, if Donna knows that she's under investigation in Nebraska with her license and she's going to get her license revoked as a result of what she did, she's going to leave and move to Florida. And at the time she leaves, she's going to say, I have a valid license in Nebraska. And they're going to check it and they're going to say, you're right, you do. So we're going to give you reciprocity in Florida. Welcome to Florida as a practitioner. Now, what Donna is hoping is not going to happen is the employer is monitoring her Nebraska license, because when that does get revoked, 3, 4, 5, 6 months after she gets to Florida. And as a result, that turns into an exclusion that makes it to the OIG. If you're not monitoring, you have multiple missed opportunities to have avoided fines while Donna was trying to get ahead of her problem. So in the interest of time to open up for questions, we came up with 3 takeaways that if you learn nothing else, we want you to know. For the pre-employment side, you do need a separate release and authorization. Please do not combine them in one form. And it must be obtained before the background check is ordered. The employer has to provide notice and an opportunity for the applicant to challenge any what would be considered adverse information before you make a decision. 5 days is typically standard. And then don't forget that there are all kinds of state variations on what questions you can ask, depending on how far back they can report and whether or not there are certain required background checks to comply with healthcare law. On the exclusion side, a little simpler. You need to be monitoring your employees and vendors on a monthly basis so the OIG does not fine your organization for submitting claims on an excluded party. If you're doing just the OIG, which a lot of people have a misnomer and are doing, you are not actually containing all of the possible exclusions. You should at least be adding the states that do exist in addition. But all of the fines are 100% avoidable by doing monthly monitoring. We want to also let you know that both Universal and Provider Trust will be proudly at ASHHRA coming up in Pittsburgh. If you're there, please come see both of us. We put on the map where our booths are. We'd love to be able to spend some more time with you on that. Matt, let's take a look at whatever questions may have come in and try to address those in the remaining minutes that we've had.
Yeah, so just before we do that, I do want to just repeat one more time that you guys will all be receiving a recording, a copy of the slides and your CEU certificate, as well as we have a survey after the webinar. We want to grow and get better and make sure that we give you guys the kinds of presentations that are valuable to you. So if you will just fill that out at the end, that'll help us get better as a company and help us help you. So let's get into some questions. There are a bunch. And if we don't get to it, which we won't get to all of them, but the ones that we don't, we will reach out individually and follow up with you all. So thanks so much for sending them in. Okay, here we go. First question from Judy. It's actually, sorry. First question is from Jerry. Are federal and or state regulations prescriptive for employees who request a recommendation for future employment? That's a
question for Alan, and Alan is going to have is jumping off to join another webinar in May. Alan, are you still on with us?
I'll send that one to Alan.
Jerry, we'll get Alan to respond to you on that. He had 2 webinars back to back and was going to have to dial into the other one, and I apologize.
Adam asked the question, what sort of exclusions are healthcare related in the SAM that would now show up on the OIG's exclusion list?
Okay, and is the question that would now or not show up? I'm going to assume that would not show up. So SAM is a federal data set that typically is mirroring that of at least the OIG. So supposedly in the OIG or in the SAM data set, it is supposed to contain all of the duplicates of what would be in the OIG. You would typically never find a SAM record without it also having dealt with at the OIG or some other agency. But the agencies that are healthcare related are the Office of Personnel Management, Department of Health and Human Services, and it can be FDA if it's a department. Those are the 3 major federal agencies. There are a few others, but what's not included in our statistics would be EPA or Department of Defense, which can also what they call sanction somebody and put them in SAM. The purpose of SAM is to let you know that an individual or an entity has either defaulted under their contract with the federal government, with GSA, or they've breached their government, and then they layer on top of it supposedly the OIG records. I want to make sure you do not hear me say, because I would not rely on SAM as your OIG search. You cannot prove compliance by doing SAM search and say, therefore, I did the OIG. You have to search the OIG separately. So SAM is another contract database to search. The OIG, they don't have the authority to fine you like the OIG does. So make sure you're searching at minimum the OIG and decide if your risk tolerance would allow you to not have all the state exclusions that are not going to be in the OIG.
Thanks, Mike. Robbie has a question here. Are we required to check all 42 states? If so, can you state which regulatory body or authority says that we need to do this?
Yeah, so this is a really debated question. You are not required. Let me tell you what risk you are assuming, but if you do not, however. So the Affordable Care Act, Section 6501, says that if an individual is terminated by Medicaid in any one state, they're not eligible to receive and apply for and become Medicaid provider in another state. The problem is that it does happen. And the OIG knows that there are people who are terminated in Oregon from Medicaid, and yet against the law, Virginia is not searching data sets and finding it, and so they grant them a Medicaid provider enrollment over in Virginia. And so the best way to avoid that for looking for Medicaid issues is to search the states. If you are excluded in Oregon and you move to Virginia, can you technically bill Virginia Medicaid even though you're excluded in Oregon? The OIG says yes, you can. They're not happy about it. They wished it was not the case. But if you're not yet excluded in the state in which you're practicing, the exclusion you have in another state is information that you should be aware of and can present a risk for you. You also need to be confident that your provider in Virginia has nothing to do with any federal billings in Oregon. And you have to make sure that they're not separately excluded by Medicare at the OIG. So it presents a big open door for you by not including the other states. The best practice is to search all and to know what that exclusion is. Would you want a provider in Virginia that is not excluded at Virginia Medicaid, but is in Oregon for patient abuse or sexual abuse or fraud and abuse? And Donna, maybe you want to add something to that.
I was just going to say, I know that states like California, for example, will have reciprocal exclusions. So when they see it in another state, they will immediately exclude that same person in their state.
And that's true. So you may see that someone stemmed from Oregon, but is also on the California list. So best practice is to search all states.
Great, thanks guys. We have time for just a couple more questions. RJ has a couple questions here really about specifying what constitutes a vendor. So can you guys help define what a vendor might be?
RJ, the best place to look is the Special Advisory Bulletin of 2013. We have the link in the PowerPoint coming to you. Anybody is considered receiving funds from and paid through CMS or Medicare, Medicaid, et cetera. A vendor is a vendor, whether you're $5 or $500,000. You have to decide your risk tolerance. But what I can tell you is not the factor for which you should be basing is whether or not they have direct access to a patient or a patient record. So that could very well mean, and there have been entities, for example, cleaning services that are excluded. And they, you would think, why would I have to search a cleaning service? They don't touch patients, they're in a room, they're cleaning up a room. But the OIG has fined organizations like that because you're using federal healthcare dollars to pay for those services. So follow the dollar. Just follow the dollar. If you are confident the dollars you're using to pay those vendors cannot be traced to CHIPS, TRICARE, Medicare, Medicaid, and it's private pay, but they're excluded, you will not have a problem with the OIG fining you. It's very limited in scope, and so therefore anyone follow the dollar on those vendors.
Thanks, Mike. We are going to close out here, but I know there are a lot of unanswered questions. We'll get back to you all individually, and thanks so much for submitting those. I do want to say thank you for attending today. We love putting these on and really love the crowds that it brings. and are happy to host these. Please, once again, submit the answers to that survey to help us get better at these and provide the kind of stuff that you guys want to hear about. So on behalf of all of us, thanks so much, and hope you have a great rest of the week.
Thank you.